Um, Good morning, everyone, and welcome to the Dalles Chamber of Community Affairs. Today, Jeff Burgess is our guest with the Bureau of Labor and Industry, BOLI. Sometimes people have a little tremble and fear when they hear the word BOLI, and we're here today to relieve that and give you a little bit more peace of mind when you hear the word BOLI. I have used their services numerous times. Dylan, the chief in charge, for the department that I go to has helped me out numerous times, and I've actually been able to refer a lot of different people from even Eastern Oregon dealing with some issues, and they didn't know how and what they needed to do, and sent them to Dylan and saved them numerous hours and then a lot of money. And because they found out they were already doing it right, they just needed to do this, this, and this, and then it was all set, and it protected them in a situation that was really, really awkward. So I am one of the first to call up Dylan and say, I need help. I wanted to make sure that we gave that information to all of you. This is being recorded, so for those who are going to watch this later, this is a tremendous resource, and I will be putting Jeff's information into the chat so that you have it later. But I also put the PDF of his presentation that has the lines for taking notes. It's in the chat so that if you wanted to download it later, you could, but you will also have this recording to do that. But before we begin, Jeff, we're going to introduce the people on the screen so you kind of know who's here. I know we're small, but these guys are movers and shakers, and they get the word out to the different people that need to hear this. So we're going to start with this. So I'm going to start with Dan Spots.
Thank you, Lisa. Dylan, good morning. Thank you for joining. Dan Spots, I'm Economic Development Officer with the City of Dalles. And Lisa, if I could give a brief update for the group regarding urban renewal, very brief. This past Monday, with the support and thanks to Commissioner Brady and so many other people, the City Council approved an expansion of spending authority for the Urban Renewal Agency. This allows us to invest the TIF, the tax increment financing collections that we would be receiving between 2026 and 2029, still closing down the district in 2029 as we are committed to do. But now we have about 6.1 million additional spending authority, and we have a long list of projects, one public project, the First Street, and many private projects downtown the Dalles, with the mission of urban renewal to mitigate blight, long time blighted conditions in downtown buildings. So that's going to be a tremendous boost downtown. And again, thanks to all for the support on this. All of the taxing districts but one supported this move despite the impact that each one of them has from tax increment financing. So again, that's a little bit chatty for a short update, but I just wanted to let folks know.
Thank you, Dan. I will reach out to you later because I have a few more questions on what those projects can be and what they can't be, but that's another discussion on another day. So Dave Peters.
Good morning, everybody. Good morning, Jeff. Dave Peters, Columbia Cascade Housing, Mid-Columbia Housing Authority. I don't think I have anything too much to report. I'm kind of sick, so I'll keep it short. Thanks.
Well, take care of yourself. All right,
I have been.
Okay.
Oh,
Scott.
sorry. Scott McKay. I'm the community liaison for Circles of Care, and we're a nonprofit under Age Plus, and we help support older adults by matching them with a volunteer for friendly visits or transportation or grocery shopping. The other thing I like to mention is that Circles of Care is involved with a dementia-friendly community effort. Well, dementia-friendly Wasco County effort in the Dalles and Wasco County. We had our most recent meeting last Friday. We had 12 people attend, and we're looking at identifying different steps we can take to make the Dalles more and Wasco County more dementia-friendly. And we have another meeting coming up next Friday, the 20th, at the Senior Center at 10 o'clock. And Tracy Morgan will join us on that day. And Tracy is the executive director of the Oregon and Southwest Washington Alzheimer's Association. They have received a grant to help support rural counties in rural Oregon to help promote brain health and better understanding of Alzheimer's and dementia. So anyone is invited. Once again, it's 10 o'clock next Friday, the 20th, at the Mid-Columbia Senior Center. So thank you.
Got Phil.
Good morning, Phil Brady, Wasco County Commissioner. I'm a little sleepy this morning and if you have any, I'm going to say Mexican because that's going to be more precise. Friends, workers today, and they look sleepy because they were all up at 5 o'clock this morning. Today is Fiesta de la, I got it wrong there, Virgen de Guadalupe. So there were mariachi bands playing at St. Peter Church this morning, starting at 5 o'clock. Then once you got there, you were not asleep. It was full bass and full trumpets all the way up. Other things I'm I can't resist this, but we missed it last night, and we have a chance maybe tonight. Is the Geminid meteor shower? Sorry, it's clouded out, and there's a full moon, so we're gonna miss it. Little traces of comet fate and are zooming into our atmosphere once again this year. Otherwise, county business is kind of slowing down. I'm very glad that the urban area and the urban renewal passed, and we'll be able to proceed with that. That'll be great. Thank you, Dan, for shepherding that through.
Thanks, Phil. Corliss.
Good morning, everyone. Corliss Marsh, Senior Center, Library, Habitat for Humanity, and no updates this morning.
Wow. Okay, I'm not used to that, Corliss. All right. Thank you so much. I know you do an amazing amount of work in our community. We would be, yeah, we're grateful. Valerie, would you like to introduce yourself?
Sure thing. Hi, good morning. I'm Valerie Egan with Business Oregon, Regional Development Officer serving Hood River, Wasco, and Sherman counties.
Thanks for being here. It's good to see you. Even if it's on screen, it's still good to see you. So with that, Lisa with the Dalles Chamber, there is lots of things going on in our community to help celebrate the holidays, to encourage shopping local. I would suggest that you go and look at the community calendar at thedalleschamber.com. There is more than you can achieve. I guarantee it. But I do want to call attention to this Saturday is the Sip and Shop. It'll be downtown the Dalles with the Dalles Main Street. And that is another fun way to encourage people to be out and about after hours to do shopping and supporting local. So there is all kinds of activities and quite the list of businesses participating. It is on the Facebook for both the Dalles Main Street and the Dalles Chamber. We've put a list out of all those businesses that are participating. So we encourage you, get that shopping done. Some of us haven't even started. So we'll be catching up this weekend. And then most of all, just drive safe and always check on your neighbors. Especially as we get into the winter weather, it's kind of like when it's hot in the summer, just check on your neighbors, make sure they're doing okay, take some coffee over or tea over and just have a visit. Especially if they don't have family that lives close by, I bet you they would so appreciate a conversation. So with that, Jeff, it is all yours and you get to take over this. And then if you need me to do anything, I will watch for questions and hands raised, because I know if you're sharing a screen, it's a little bit challenging to see both.
Thank you, Lisa. Good morning, everybody. Let me share my screen here and then we'll get rolling. Everybody see that okay?
Yes, we see it.
Yes.
Great. Yes.
All right, great. And I'll take a peek at the chat from time to time too. If folks have questions, thoughts, comments, gripes, feel free to raise your hand, jump in, unmute yourselves with questions, or put a question in the chat. See if you can stump the trainer here. It is a pleasure to be with you this morning. I'm from the government and I'm here to help. I think it was Ronald Reagan that said those are the 9 scariest words in the English language, but I am privileged to work in a job where I believe that to be true. And glad, Lisa, that you gave a shout out to my manager, Dylan Morgan. So let me just talk a little bit about what we do and why we do it. Then thought it might be useful to have a little bit of substantive content just for giggles. And so we'll talk about some recent developments on the regulatory front. So let's get right to it. We're a fairly small team of 8. We've got 6 trainers like me. We've got oh my goodness. Oh no, I did not leave Carly out. Carly Rodriguez is a bit unique in that she shares her role with employer assistance half-time and with our apprenticeship and training division. But I make special mention of her because she's our Eastern Oregon representative. And so to the extent that you have a chance, she gets out and about in the community, and she's a great resource for folks who are interested in starting it or continuing an apprenticeship program, have questions about that, or any of the stuff that we talk about, which is just about everything involving employment law, supervision of employees, best practices. At the outset, I would say we can't give legal advice. Just a bit of background about myself. I was an attorney for 15 years in private practice, and then came on board back in 2002 at BOLI as an agency prosecutor. And so I had the opportunity to take and the privilege to take wage and hour cases and discrimination cases to administrative hearing before an administrative law judge. So having seen how things can go terribly wrong in workplaces elsewhere, seemed like a bad thing at the time. I got laid off back in, about 15 years ago when the economy was circling the drain, and we lost one of our 2 administrative law judges. She had seniority. You probably know how that works. I got displaced and looked around for the best job available, and that was in the prevailing wage rate unit, where I got to spend all day, every day, going through big boxes of certified payroll records and putting that data in spreadsheets and busting employers who misclassified somebody as a power equipment operator 2 instead of a power equipment operator 1. And that was not for me. And so mercifully, TA came calling, and I've been here ever since. It's now EA, employer assistance. We were technical assistance for employers for a while, and so we'd get questions about people's computer systems and stuff, and I'm kind of a technological dinosaur, so we've rebranded as employer assistance, but we're just here to help folks figure stuff out. And I think we're particularly well suited for smaller organizations that don't have a team of HR professionals to guide them through the morass of regulations and red tape. And we really are I think uniquely situated to help folks figure stuff out and get it right. And so you can always reach out to me if you've got a question about any area of state or federal employment law. Again, I can't give you legal advice, but I can give you information. I think that knowledge is power. And we can do research for you. We can even take your name out of the question, your organization's name, and run the question up the flagpole to our enforcement divisions. If you had this scenario, what would your enforcement perspective be? That can be really valuable. We collaborate really closely as a team and as an agency to try to give folks good information about what is, what was, what's coming. And so please don't hesitate. You can always reach out to our team. If I happen to be away, you can use the team email address or the team phone number that rings around at all of our workstations. And we just got some statistics. We're answering most of the phone calls that we get as they come in. So yesterday I had a delightful person just express shock and surprise and glee that they reached out to a government person and got a live person on the phone, and we were able to work through some kind of thorny issues, and that was fun. Folks that, unlike in litigation that I did in the past, folks that we work with are typically pretty nice and pretty grateful. Not that folks that are litigating cases aren't nice, but they're going through a rough patch, and so we're not always seeing people at their best in that environment. And compared to the scorched earth and kind of adversarial nature of litigation, this work is a daisy-filled meadow by comparison. So please don't hesitate to reach out, and hopefully by the end of this presentation, you'll feel like you've got at least one friend in state government. And we take the approach of no wrong door to state government. So if you've got a question about tax, I know virtually nothing about taxes. So we'll connect you with Chris Cox, public service representative at Department of Revenue. We've got a pretty good network of resources available for folks, and lots of good information on our website. So if you do leave us a voicemail, we're almost always able to get back to you within one business day. But meanwhile, you can go on our website. There's a link to our webpage where there's just a ton of great information for employers, and we'll take a little tour of that here in a minute. But you've got my direct contact information, so be pleased to build a relationship with you. And that's one of the really nice things about this job is over the years, I've actually become friends with a lot of folks in the community that reach out to us. And some people will contact me 2-3 times a week, and that's fine. We're there to help. So this is a really important slide, and we take this firewall very seriously between us and the enforcement divisions. So loosely described, our agency is led by our Labor Commissioner Christina Stephenson, and she's been with us coming up on 2 years now. Her stewardship is over 3 primary divisions: apprenticeship and training, and one of those representatives is Carly Rodriguez, as I said. They have about 165 different apprenticeship committees or apprenticeship programs throughout the state. They work with trade schools, with community colleges, with employers, even with the prisons, to help folks get into good living wage jobs in Oregon, typically in the trades. My tenure at BOLI over 22 years now has been more connected with the wage and hour and civil rights divisions, as I've worked with the enforcement folks and with the employer community now over the last 15 years to help folks navigate rest and meal periods rules and final paycheck rules, which are incredibly strict. And then on the civil rights side, we're talking about discrimination cases, or a particularly egregious form of discrimination is harassment, which we'll talk a little bit about at the end of the presentation. So primarily in employment, but also in housing and places of public accommodations. And then over there on the right side of the firewall is employer assistance, and we're actually part of the commissioner's office. So this is not a terribly accurate flowchart, but we take that firewall very seriously. We don't want there to be a chilling effect between you and getting good information. If you've got a problem, fix the problem, and we'll try to help you do that. We'll try to, if we can't give you legal advice, but we're happy to say, well, these are some best practices. And if you choose to go a different way, we would strongly urge you to talk to counsel. So we don't give legal advice, but we're quick to say that this is an area that might be of great risk to you, and here's why. And we try to spot issues. So it's kind of fun when the phone rings or the email pings and we get a question to not just answer that particular question if we can, like by what the law says, or what courts have done, or what we think best practices are, but other issues that might be related to that core question. And that's kind of a fun part of the exercise. If you don't believe me that we have this firewall between us and the enforcement folks, oh, and I see Phil's got a hand raised. Yeah. So let me just finish this thought, Phil, and I'd love to hear your question. I just want to say that if you don't believe me about this firewall, and that we're not going to rat you out to our enforcement colleagues, you can always phone for a friend. You can make up a hypothetical, and sometimes the hypothetical questions that we get are incredibly detailed and specific. We suspect they are not so hypothetical, but we're happy to play that game with you. So Phil, what's your question or comment?
You're on mute.
In the Gorge, there's been an issue developing, and I'm going to kind of question, what is your relationship to OSHA? And the issue has been around farm worker housing. There's an advocacy group petitioning OSHA to increase the size of housing here. So if I'm an orchardist, I would come talk to you, and that would be on the employer side. And so it's kind of two kind of questions. This is an example of what you're talking about. An employee has confidentiality, But then the second part of the question is, what's your relationship to OSHA?
Great question, Phil. Thank you for that. We have a kind of a loose relationship with OSHA, and by that I mean we've got some regulations and some statutory guidance that is related to the protections that folks have who complain about an unsafe or unhealthy working condition. And so, for example, the legislature during COVID, there were just a flood of OSHA complaints about unsafe and unhealthy working conditions, folks not wearing masks, not being vaccinated, not sanitizing commonly touched surfaces. And folks were really concerned about coming to work and staying safe. And that's what the general duty clause of the Occupational Safety and Health, the Oregon, the name of this act is escaping me right now, but it's the Safe Employment Act, something like that. And so the legislature passed a statute that now creates a presumption that if an employee reports unsafe or unhealthy working conditions and then suffers any adverse employment action within 60 days thereafter, there's a presumption that it's in retaliation for having brought that health and safety complaint. That doesn't mean that employees get a free pass from disciplinary action or adverse employment actions if they make a health and safety complaint. It just compels employers to show their work and to show that they have legitimate non-discriminatory reasons for discipline or termination of the employee unrelated to the health and safety complaint. So I've referred lots of folks to OSHA. There are some relatively new OSHA rules concerning excessive heat and air quality index standards. Most of the, well, all, to my knowledge, all of the COVID era OSHA regulations have now been withdrawn. So we're referring folks to the Oregon Health Authority for questions about return to work following COVID. But in terms of farm worker housing, this initiative is news to me, but to the extent that an employee, a farm worker, lives in housing provided by the orchard or store employer, there are certain protections, statutory protections that go along with that. The right to access public services, for example, the right to have a telephone available, and so forth. To the extent that folks came to us with questions about how to navigate those OSHA regulations, we would certainly help try to figure that out. We could refer them to folks at OSHA who might be able to help further, or help them navigate the OSHA website, try to find the rules and regulations that might be applicable. But it's really all about keeping folks safe at work, and whether that's in housing connected to their employment or in employment in general. For example, the protections that are in our workplace postings for agricultural workers not being exposed to, or who are exposed to, mitigating the dangers of being exposed to pesticides and the like. That's the kind of thing that we can help employers figure out if they have questions about that. So I hope that's helpful.
Yep, thank you. And I'll assert that our orchardists do a very good job here in Wasco and Hood River counties.
All right, I'm sure they do. Hopefully you will take that firewall to heart, but if not, definitely phone for a friend. Don't let that keep you from contacting us if you think there's an issue at work. I've embedded some hyperlinks into this slide, and they are for links to the services that we provide. Some of them are at a cost, some of them are free. Most of them are free, actually, and free is a pretty good price. So if you wanted to download and print off the commonly required workplace postings, that's free, or you could purchase a composite poster for $18 that's in English on one side and Spanish on the other. Our handbooks are available for a cost, and the reason why we do what we do the way we do it is that our program is almost entirely unfunded by your tax dollars. My entire salary is funded by other funds, which we generate from, frankly, putting butts in seats and having folks attend our seminars, our annual employment law conference, buying our handbooks and posters, and that helps fund the free services that we provide. We've got handbooks. I'll take a little closer look at those in a moment. we can come to your shop and do personalized on-site training. We also offer about 150 different public seminars throughout the year on such things as leave laws, like Paid Leave Oregon and the Oregon Family Leave Act and the Federal Family and Medical Leave Act and Oregon Sick Time. And how do all those work together? It's pretty complicated stuff. It's kind of the brain surgery of HR. And wage and hour, documentation, discipline and discharge, effective supervisory practices, legal hiring practices, drug and alcohol issues in the workplace. Just the list goes on. And there's a link to our training page where there's information about our on-site and our public offerings, a calendar and descriptions of all those trainings, the costs associated with those. If you had us come out or train your folks virtually, virtual training or training within 50 miles of our Portland offices is there's a 2-hour minimum at $275 an hour, $275 an hour. Not too bad. And it's been that rate for the 15 years that I've been in employer assistance. But we can tailor make a training depending on your training needs and your training dollars available, and customize that training for your organization. That's sometimes useful, and sometimes there's a cost savings involved rather than sending a bunch of your supervisors, for example, to a public seminar. You can call us, you can email us, as I said, with questions about any area of state or federal employment law. And if we know the answer, we'll give it to you. If we don't, we'll hunt it down for you. And we love those research projects. Oh, glad to know, Lisa, those hyperlinks are working in that PDF that you supplied to the attendees. That's nice. Our website has a bunch of fact sheets, probably, I don't know, 30 or 40 of them, I'm guessing, on areas of common concern for employers, like, what can I take out of a paycheck? Can I recoup an overpayment out of a paycheck? Short answer, no. But there are ways to recover overpayments. The employee doesn't get to keep that money that they that they were paid inadvertently. It can be a little bit tricky, but we'll help you navigate those processes. We've got a disability accommodations toolkit. So if you have an employee that comes to you and says, I hereby request a reasonable accommodation under the Americans with Disabilities Act. Well, people don't talk like that. They say, I got this thing, I've got this back issue or this knee issue or this mental health issue. Frankly, we're seeing a lot more of those. And I think it's hopefully because of the fact that the stigma of mental health issues has gone away to a large degree in workplaces out there. And so folks are more forthcoming about their mental health struggles. And that could be a disability and require some reasonable accommodation, maybe reasonable amount of time off for treatment that would be unpaid, or maybe someone has a mobility impairment and they need access to the work site, or maybe they have a visual impairment, they need a larger computer monitor, something like that. We can help you with some tools to navigate that very tricky process, and super important to document as you go along. So check that out, bookmark that page. It's super useful. When's the final paycheck due? One of the more common questions that we get probably on a week in, week out basis. There is a listserv, and we're not going to flood your email inbox with daily or weekly, but maybe monthly or quarterly. We'll send you a note that says, hey, here are a couple of things coming. Here's our quarterly training schedule. Here's a change in the minimum wage, whatever it may be. So you can sign up, you can unsubscribe at any time. We don't rent or sell your email address to anybody else, but it's a good way to stay connected with us and get periodic updates of what's going on. And then once a year, this year was our 40th annual employment law conference. We had over 700 attendees. It's an all virtual conference now, which makes it a little easier in terms of travel and lodging and all of that. Some people miss the old fashioned conference that was in the Portland Convention Center. We've toyed with the idea of trying to do some sort of a hybrid conference, but most folks like the virtual conference because they can attend all of the sessions. There are 2 sessions going on at any one time. They can attend whichever one they choose, but then they get a recording of the live session that they missed, and they can download those recordings and listen to them later. So it's a great opportunity to connect with experts in the field, whether they're attorneys, HR professionals, our training staff. We try to keep it fresh and relevant year in, year out, and we hope you'll consider attending at some point down the road. And there's our brand new office space at Harrison Square in Portland. We've moved across the river. We're no longer in the Portland State Office building, which is that building on the left. But here's our website. And so if you go to oregon.gov/BOLI/employers, you're going to see a dashboard allowing you to check out our training schedule. Just below the banner, there's a link to view FAQs and fact sheets that I highlighted earlier. And there's a hyperlink there for you. Child labor issues, harassment, all kinds of resources like hiring employees, getting a farm, forest, labor contractors license or property services license. If you've got a project on a prevailing wage project, then we can connect you with folks in prevailing wage who can help you fill out certified payrolls and make sure you're getting that right. But lots of good stuff on our website, including our handbooks. So these are our current offerings. Actually, it's a little dated. I didn't capture a screenshot of the current offerings, but they're the same. We just update these handbooks every year. I just noticed that they were 2022. So there are 2024 versions of these handbooks available. They are electronic now. And I know if you're like me, you like to actually turn the pages of a book. My current read is Greg Isles, Southern Man, awesome read. It's a tome. It's taking me a while to get through, but I love turning pages. You can print those out. You can dog ear them. You can put Post-its on them. You can mark them up. But the nice thing about the electronic ones, you go through the table of contents, you see something you want, you click on that subject in the table of contents, it jumps you right to the content, and we can update those throughout the year. And anybody that has purchased a handbook that year from us, to the extent that we update something like we just did, in terms of what I'm going to talk about in a minute, which is the salary basis rules for exempt employees, you'll get an update electronically, and then you'll have the most current version of our handbook throughout the year instead of, well, I've got this hard copy that was from 3 years ago, and I don't know if it's still current and relevant. But the most popular one there is the Leave Laws Handbook. I also really like the Wage and Hour Handbook, because and I don't see it there, but it is an offering. And we actually even have a handbook on putting together employee handbooks. So a handbook on handbooks. That sounds a little strange, but it's a useful document. So is the legal hiring one. The classification one is not so popular, but if you've got a question about whether your employee in a particular trade or a salaried employee can truly be classified as exempt, that can be useful. And if you don't purchase that one, if you got questions, reach out to me, and I can even send you some excerpts of that one relevant to your organization.
Okay, hang on, Jeff. Dan,
Yes.
you have a question?
Thank you, Lisa. Yeah, but just a question on the hard copy, and I'm exactly the same way. I'd like to have a print version, with the downside that they get updated. I saw the 2022 references on there. If you get a hard copy, any idea how long that's going to be current?
Yeah, a great question, Dan. So it's current until something changes. So that's not a very good answer. So I guess most of the questions we get could be answered with the statement, it depends. But then we go on to tell you what it depends on. So to the extent that the legislature, it's getting cranked up here after the first of the year, they pass new laws, rulemaking bodies implement new regulations, state and federal. We try to keep those updated. So we're doing new versions of every handbook every year. And almost always there's some substantive update that needs revision. That doesn't necessarily mean you need to purchase those every year. You could, and we wouldn't discourage you from doing that, as it supports our services and helps pay my salary. But the handbooks aren't, they might change in 3 or 4 or a dozen places throughout a year, and we'll give those updates in the fact sheets and FAQs on our website. We'll certainly give you those if you call or email us. But most of that stuff doesn't change year over year. But I wouldn't be too complacent about relying on a 5-year-old handbook to tell you what the current state of the law is. So when in doubt, definitely reach out and we'll try to help with that.
Awesome. Thank you.
Great question. Yeah. So our kind of mantra is, if employers get it, everyone wins. There's a business case for doing the right thing by your employees. And I think that helps with recruitment and retention. The Dalles is a relatively small community, and word gets around if you're one of those great places to work, or maybe not so much. And that helps to keep the investigators off your backs and plaintiffs' lawyers who would like to extract money from your pockets if you're doing something wrong. And we think that it helps for morale. It helps employees be more productive. And to the extent that you're not just meeting, but even exceeding the legal requirements, yes, you can pay folks a nickel more than minimum wage. That's perfectly okay. I see a bright line of demarcation out there between employers that just want to do the bare minimum for their employees and extract everything they can out of them, and those employers that really want to go above and beyond and create a family-like atmosphere within the organization, and that really is beneficial in the long run. So it takes cases off of the desks of our enforcement colleagues who are frankly overwhelmed. And in the governor's recommended budget that just was released a couple of weeks ago, she advocated for a substantial increase in funding for BOLI to help clear out some of those backlogs. But if you get embroiled, and every organization that's around long enough is vulnerable to a claim or complaint, it doesn't mean it has merit. Maybe 85 to 90% of the civil rights complaints that we get are dismissed. That's good news for employers. It doesn't mean that the discrimination didn't happen. It just may mean that we can't prove it. So it's nice to keep doing the good work that you're doing in the community without having to face the expense and the uncertainty and frankly the time suck of defending a lawsuit. So we are not done, Phil. So maybe Lisa, if you could let Phil know that maybe he's got a sound problem on his end. If he leaves and comes back, that may fix it. That usually does. Thank you. So it's good for our compliance staff. It's good for employers. It's good for employees. And we really appreciate when employers are trying to do the right thing. Phil, I see your hand up. Do you have another question? Or is that from before?
New question.
Thank you.
Since you've seen just about everything, you may have seen instances where employees are gaming the system and they know the rules and they're trying to squeeze a pay what do I call it? Set up a situation where the employee appears to be discriminating in one way or another. What advice do you have to employees when they start to get that sense that they've got one of those employees who's gaming the system?
It's a great question, Phil. I've seen it. I think it's relatively rare, and that's good news, but it does happen. I prosecuted a case, sort of, against an employer, and this employee was going around with a little notebook trying to drum up reasons to file an OSHA complaint against his employer, and it was just really petty stuff. And at the bottom, he said there's a gold mine of violations, and I think he was looking for the gold. And so we structured a kind of a nuisance value settlement to make that one go away. But I heard from an employer last week that had an employee who was applying for paid leave Oregon and had bragged to his coworkers that he, sorry for the euphemism, but he said to his coworkers that he had his employer by the balls and was totally gaming the system so that he could take Mondays and Fridays off for no good reason. And paid leave Oregon had granted the claim, but because of the circumstances where he had requested vacation was denied, and then he applied for paid leave Oregon for those very same days. I encourage the employer to proceed with caution and to talk with counsel, but that one strategy might be to document all of this. Documents win cases, and if it's not written down, it didn't happen, kind of our mantra too. And there's a fraud unit at Paid Leave Oregon, and I think there was sufficient evidence of fraudulent use of Paid Leave Oregon to avoid work requirements. And with that information, Paid Leave Oregon could deny the claim, and the employer might, with the advice of counsel, consider some adverse employment action against the employee. It's risky in connection with a protected leave event, maybe, unless the employee truly is abusing the leave, but it happens. And when it does, investigating, documenting, trying to be able to demonstrate what happens and showing your legitimate non-discriminatory reasons. For example, good comparator evidence might show that that same employer had 12 other employees take paid leave Oregon, and they didn't suffer any adverse employment consequences as a result. And this person, for other reasons, maybe related to performance or maybe their abuse of leave, it might be a defensible termination. So challenging to manage employees, particularly in Oregon. It's a fairly employee-friendly state, as you may have gathered, but there are ways to navigate those situations to minimize the risk, to rein in those very few, I think, rogue employees who would game the system. But I'm not going to say it's easy, and I'm not going to say it's without risk. So the way you proceed with caution, with good documentation, with good investigation can certainly help you navigate those thorny situations. So I've talked about the resources that we provide. We really do want to try to help folks figure stuff out and get it right. And as I said earlier, too, it's about building relationships with folks over time. And I just love those kind of repeat customers that come back and we get to know each other a little bit and what we're doing for vacation and what our families are doing and so forth. So just in the last 15 minutes here, I'd like to give you some information about a couple of things. The first two were big pieces of regulation that, for now anyway, have gone away. And so that's why I say never mind in terms of the salary increase for the U.S. Department of Labor. These are very recent changes. And the Corporate Transparency Act, I don't know if you heard about that. I hadn't heard about it until a couple of weeks ago, but folks were calling me alarmed that they were getting some very official looking notices that they had to file something with FinCEN, the Financial Crimes Enforcement Network of the U.S. Treasury. That sounds pretty scary. So we'll talk about those two things real quickly, and then some pending rules that are just about to go final, beefing up requirements for employers who are responding to harassment allegations. So getting right to it. You might have heard that July 1st, the salary requirements for those so-called white-collar exempt employees, the professionals, executives, and administrative employees who are paid on a salary basis and who meet certain duties tests, went from $684 a week to $844 a week. Further increases were scheduled for January 1st and July 2027 and every 3 years thereafter. But the Eastern District of Texas, U.S. District Court, put the brakes on all of that and said, wait a minute, this is unconstitutional, exceeds the rulemaking authority of the U.S. Department of Labor. And this has happened before. And it happened before at the end of the Obama administration, and the Trump administration chose not to appeal that ruling. Well, we're on the threshold of another Trump administration, so it may change. But I suspect that the Trump administration is unlikely to appeal this order, and we're going to be back at $684 a week. Now, what do you do if you gave every salaried employee an pay increase on July 1st to $844 a week? It's tough to walk those back and preserve morale in an organization. You don't have to keep that in place, and you can let folks know in writing that as of, say, January 1st, we're going to, because these regulations have changed, we're going to move you back to $684 a week, whether you want to do that or not, or at least just know that for the time being, you're going to be spared the increases that were scheduled to come, unless there's an appeal, which I think is unlikely. That salary level is at $684 a week. So more information on our fact sheet and check for updates as we go forward. This was a pretty scary piece of legislation. This Corporate Transparency Act was requiring employers, and a lot of them did so. This went into effect January 1st of 2024, requiring employers to provide, or organizations to provide information to the U.S. Treasury about who owns the entity, what percentage, there's even birthdays in there that had to be communicated. And again, the Eastern District of Texas, U.S. District Court, different judge, put the brakes on this one too and said, this is quasi-Orwellian. This is an overreach. This likely does not pass constitutional muster. So as of December 3rd, just 9 days ago, the court issued an injunction blocking the enforcement of the whole Corporate Transparency Act. So check back for updates. There's a link there to the FinCEN website that has an alert now that says that these requirements are on hold and they are now voluntary. So a lot of employers that were nervous about filing something like that can breathe a little bit of a sigh of relief, but stay tuned for more developments in that regard. Both of these rulings out of the Eastern District of Texas are nationwide rulings, and so they cover employers in Oregon as well. Finally, I wanted to mention a little bit about harassment. As I said, harassment is just a particularly egregious form of discrimination. It's not just treating people differently based on their protected class status, like race, color, national origin, gender, religion, disability, age. The list goes on, and we're all members of lots of protected categories, right? I'll overshare here a little bit. I happen to be a white Anglo-Saxon Protestant heterosexual male. Guys like me have historically not been discriminated against, but these laws protect me too. So I did prosecute a case against an employer in Albany that made some pretty unfortunate statements to her white employee born in the United States that she would much rather hire a Mexican. She said to her employee, her white employee, that Mexicans worked harder and cheaper and faster and didn't take as much time off. And those are unfair, stereotypical comments, unfair to the white employee and to her Latinx coworkers. And so she was protected by those laws, even though she's not in a subcategory of those protected classes that's been historically discriminated against. So what is harassment? The legal elements of a harassment claim are words or physical conduct that are related to somebody's protected class status, that are severe or pervasive enough to create a hostile, intimidating, or offensive work environment, or interfere with somebody's ability to do their job. And the cases we hear about in the news are the sexual harassment cases, pretty rampant, such that it gave rise to the Me Too movement, you might remember. And the legislature's response to that Me Too movement was to implement the Workplace Fairness Act, which gives new teeth to solve an old and deeply entrenched problem in our culture, which is sexual harassment, sexual assault, and discrimination. And so because of that, the Workplace Fairness Act requires all employers to have an anti-harassment policy on the books, and we recommend that wholeheartedly, even if the law didn't require it. You may have no more important policy in your handbook than your anti-harassment, anti-discrimination policy. You want to make sure you're protecting folks from retaliation, as that can make a bad case exponentially worse and more expensive for the employer. So the Workplace Fairness Act says the statute of limitations for most discrimination claims is now 5 years and not 1 year. And there's a requirement that you provide this complying policy that has certain provisions, a pathway for reporting harassment and an alternate pathway in case the designated person to report harassment to is the harasser, or the employee is just not comfortable going to that particular person. Often it's any member of the management team or HR or the president or executive director of the organization. The policy recommends that folks document what happened. As I said, documents win cases. And so there's some provisions prohibiting no rehire, anti-disparagement, and other provisions in settlement agreements unless the person accusing the employer or a coworker of harassment or discrimination wants those provisions to be put in. So make sure that I'm seeing in the employers that I work with, about half of them have a complying Workplace Fairness Act policy in place. So it's a good reminder that your homework assignment for the day is to check your policy and make sure that it's in there. So what's this new set of rules about? It defines what is appropriate corrective action. So if you learn, or if you should have known that harassment, discrimination, or sexual assault was going on in your organization, you've got a duty to do something and take prompt and effective corrective action once you've figured out. So you get an allegation, you investigate, find out what happened. An investigation is a search for the truth. And then if you find that harassment occurred, you've got to take prompt and effective corrective action designed to stop the harassment and to prevent it from recurring. So I think we've moved beyond the situation where an employer might have the notion that some egregious form of harassment occurred and we're going to give them a stern talking to. That's probably not enough. So it may be that, if it's a milder case, we remind them of the expectations of workplace conduct, remind them of what can happen if it continues, provide them some training, give them another copy of your anti-harassment policy. So that needs to go to all employees upon hire, all existing employees. And then anytime there's an allegation of harassment or discrimination, we give them another copy. So sometimes we have to step in right away, like within 24 hours, to put some protections in place to prevent further harm. That might mean suspending somebody while we conduct an investigation. That's not a disciplinary suspension. The discipline may come later. This is to preserve the status quo, figure out what happened. And so we've seen court cases where an employer has been held to be deliberately indifferent to a complaint of harassment if they took too long to start an investigation and took too long to conclude an investigation. So a prompt, thorough, impartial investigation, appropriate and proportional corrective action, right? We don't need to kill a gnat with a sledgehammer. Fly swatter would do. So thinking about what proportional discipline might be for a first offense, a milder offense, an inappropriate joke or comment, maybe just a conversation, document that conversation, maybe remind the person of the expectations. But if it's more egregious conduct, particularly like an assault, it may be that termination is an appropriate and proportional response. We want to protect the accuser and the aggrieved party. They're sometimes one and the same. Sometimes they're two different people from any undue burden or harm. Certainly anybody that cooperates in the investigation. And the anti-retaliation protections are super important. So we want to make sure that we're having the conversation with the accused. Let's not make a bad situation worse by engaging in retaliation or having your friends do that. And to the accuser, we want them to know that we have a zero tolerance policy against retaliation. And if they get any notion that there's retaliation going on, we want to know immediately, and we're going to take steps to stop it and to protect them. So that's kind of where we're headed. Again, you want to document your response. We want it to be timely. And that's all I've got. We've got a few minutes left if folks have thoughts or questions, additional ones. I appreciate the questions so far, but I see Phil's got another hand. Thanks for the questions, Phil.
Thank you very much. Thank you for the presentation. Thank you for organizing it well. Many of us on this screen and in general work with groups that have wonderful volunteers who work in the organization. Does any of this apply to people who are volunteers or in a position where they are working without pay? Kind of different than a volunteer. I'm thinking like a board position, which is volunteer as well.
Great question, Phil. So most of these rules, regulations, statutory protections, anti-discrimination protections apply to employees. So our agency, actually in the Federal Equal Employment Opportunity Commission, don't have jurisdiction over relationships that are not employment relationships. And those are three. You pointed out volunteers. There's also a mechanism for any organization to have unpaid internships, and independent contractors are not employees. But we want to make sure we get that classification correct, as you might be surprised at some of the cases that we've had against folks who have misclassified somebody as an independent contractor when they're really an employee. There's a 6-factor economic realities test that our wage and hour division looks at. We have a fact sheet on that on our website on interns and trainees and the 7 criteria under the federal regulations for classifying somebody as an unpaid intern. But volunteers, only certain organizations can have volunteers. I had this question out of Forest Grove last week. Employer said she was trying to get a bar up and running and had a friend say she was willing to volunteer and help me get set up. That's not a permissible volunteer relationship. It has to be a religious, charitable, humanitarian, public, community service, or similar nonprofit organization. Those folks can have volunteers so long as the work truly is voluntary. And it is on the volunteer's own initiative without the expectation of compensation, and for one of those religious, charitable, community service, public, humanitarian type purposes. Employees of the organization can actually be volunteers as well. There are 2 additional criteria for them. The volunteer work has to be different from their paid duties, and their volunteer work has to fall outside of normal work hours. But I work for BOLI. I could volunteer after hours to do some event that's unrelated to my job outside of normal work hours, and that would be permissible because I work for a public entity and they can have volunteers, and sometimes we do press some volunteers into service if they're willing to do so. So those are non-employees, and most of these protections don't apply to them. The anti-discrimination protections do apply to unpaid interns. However, that was something legislature passed about 5 years ago. And so that's good to know that we can't harass or discriminate against our unpaid interns. But those classification questions can be tricky. So reach out if you've got any questions about that, and we'll try to help you navigate those regulations. Hope that's helpful.
Awesome. That's a lot of information, but thank you, Jeff. I
You're
know.
Hey, I've got one
Okay, yeah, make it quick.
question. Okay, I'll make it quick. Jeff, of course, the Society of Human Resource Professionals, but there is a local group of those in the Columbia Gorge, as I understand it. And I just wondered if you've spoken with that smaller organization. It's a regional group.
Yeah, we've worked closely with a lot of the SHRM chapters throughout the state. We put on some joint trainings. We've got a pretty good relationship with one in Roseburg, I know. And I've worked with the one in the Rogue Valley, but I don't know that I've specifically worked with the one in the Dalles or in Wasco County, but would welcome the opportunity to collaborate with those folks, either to bring some low-cost training to the community or just to consult with them periodically if they've got questions about how to proceed. SHRM is a great resource for managers, supervisors, business owners out there, and we value that relationship and would love to see it grow and continue. Thanks, Dan.
Thank you, Jeff.
And I know this is ton of information. It's like using my auctioneer voice, and from your end probably feels like drinking from a fire hose. I just wanted to give you a little taste for what we do and to know where to get more information. And so it's kind of what you need to know, what you want to know, and where to go in terms of going forward and making the most of the resources that we offer to folks.
Well, Jeff, I really, really appreciate you being here. I have used your department and had many conversations, and they've saved us money, things I didn't know. And I was like, who do I even ask? And if I ask, am I going to be in trouble? So I have really, really appreciated the employer assistance department. Like I said, I've referred so many people just when it was ag rulings and employees that we just didn't know. And it was great that we have this resource right at our fingertips. And yes, every time I've called, there's been a person who has answered the phone. I love it that it's a real person. So like I said, this is recorded. We'll be sharing it with our businesses. I think this is such essential information that everybody needs to know. And my favorite slide was, though I told you ahead of time, the never mind and the never mind. Those are 2 big issues that we did not want to deal with. I know that they're probably coming back, but for right now, they're on a delay, which is good for our businesses, that both of those were delayed. So thank you again. Everybody, I did put information into the chat, the actual employer assistance number with the email that goes with that, so you can share it with other people. And then Jeff's contact information. And then, of course, the worksheet that is this slide deck with lines, but all the hyperlinks work in that. So there you go. You've got it. I want to be respectful because it is 8. And everybody take care. Thank you again so much. Jeff, I appreciate your time early in the morning. And with that, everyone, have a super Thursday.
Thank you, Lisa. Bye, everybody.
Bye.